right, let's get right into it. This is one of those stories that sounds almost unbelievable. It's about a huge multi-million-dollar legal fight, and it all came down to the meaning of a single word. Yeah, just one word in an insurance policy, and how something as basic as rain could kick off a battle that lasted for years. So picture this, right? A massive storm just rolls through. Your business gets flooded, and your entire stock completely wiped out. But you think, hey, it's okay, I've got insurance. But then you get that letter. You know the one. Claim denied. Now, this isn't just some made-up scenario. This is exactly what happened to a company in Mumbai, and it started this legal saga that went all the way to the top. So our story really kicks off on one incredibly wet day in Mumbai. And this day, well, it set the stage for a legal fight that would drag on for over a decade. Okay, so here's the timeline. It's July 18th, 2011, and Mumbai is just getting slammed by these torrential rains. In the Andheri area, the downpour is so bad that a building actually partially collapses. And inside that building, a business called M/Geekay International. Their entire inventory, we're talking cloth, garments, totally ruined by all the water. So they do exactly what you'd expect. They file a claim with their insurer, National Insurance Company, but what they got back wasn't a check. Nope, it was a flat-out rejection. And here's the thing. This rejection, it wasn't about how much damage there was, or even if it happened. The whole fight was about one single word, and that became the million-dollar question at the very heart of this case. You see, the whole legal battle really boils down to this one simple disagreement. On one side, you have the insurance company saying, look, your policy covers flood. What happened here? That was just heavy rain, so claim denied. But on the other side, Geekay International is saying, hold on, that heavy rain caused the flooding and inundation. You have to pay up. And that single distinction, that's the whole ballgame right there. All right, so let's try to see it from the insurer's point of view. Why were they so confident they were in the right? Well, it all goes back to the specific kind of contract they sold. See, they had issued something called a named perils policy. And you've got to understand this part because it's key. It basically means the insurance only pays for disasters that are specifically named in the policy. It's like a super strict checklist. If what happened to you isn't explicitly on that list, you're not covered. Simple as that. So the insurer's logic here was really straightforward. You can almost hear them ticking the boxes, right? Number one, this is a named perils policy. 2, flood is on the list. We'll pay for that. 3, heavy rain? Not on the list. And 4, our own surveyor went out there and said the damage was from rain. So for the insurance company, the conclusion was obvious. Case closed, claim denied. But Geekay International? Oh, they were not backing down. Not at all. They came back with a really powerful legal argument that completely flipped the script and put all the pressure right back on the insurance company. They fought back using this fundamental principle in insurance law. And it basically says this: if a policy is confusing or unclear, the benefit of the doubt, the tie, if you will, goes to the customer, not the company who wrote the complicated contract in the first place. So the burden wasn't on the business to prove they were covered. It was on the insurer to prove beyond any shadow of a doubt that they were excluded. And this principle, that became their whole strategy. They argue that the insurance company's definition of flood was way too narrow and, frankly, self-serving. They said, no, what happened to us was a flood, and any confusion about that word has to be decided in our favor. So this brings us right to the absolute core of the issue. This entire multi-million rupee case now boiled down to one single, seemingly simple question. And that question was, what is the legal definition of a flood? I mean, we all think we know what a flood is, right? But what does it actually mean in a court of law? Both sides had their own answer, but only one mattered: the courts. Now, to find that answer, the court didn't have to start from scratch. They looked to a huge precedent, a landmark ruling from the Supreme Court of India in a famous case called J.K. Cement Works. And it turns out this case had already dealt with this exact problem. And here is what the Supreme Court had already decided. Legally speaking, there are actually 3 types of floods. You've got coastal floods, from the sea. You've got fluvial floods from an overflowing river or lake. And then there's a 3rd type. And this 3rd one, well, this was the key to unlocking the whole case. A pluvial flood. Pluvial. Remember that term? Because it changed everything for Geekay International. Now listen to this quote from the Supreme Court's judgment, because this is the knockout punch. A pluvial flood happens when torrential rains overwhelm the capacity of the drainage systems, leading to accumulation of water on the streets and nearby structures. I mean, does that sound familiar? It is the perfect legal description of what happened in Mumbai on July 18th, 2011. A flood caused by rain itself, not by a river or the sea. Okay, so with that legal definition locked in, the path to a final verdict was suddenly crystal clear. So let's look at how the commissions ruled and, more importantly, what this all means for you and your own policies. First, the state commission sided completely with the policyholder, Geekay International. And they didn't just tell the insurer to pay up, they actually found them guilty of deficient service. So, the insurance company appealed it, of course, but on August 16, 2024, the National Commission shut them down, dismissing the appeal and cementing the victory. And what about the money? Well, the court ordered the insurer to pay the full amount for all the ruined garments. That's over 46 lakh rupees. But it gets better. They also tacked on 9% interest per year, going all the way back to the day of the loss in 2011. A total decisive win. So, the big lesson here is pretty clear. Words matter. A lot. An insurer can't just invent its own narrow, self-serving definition for a word like flood, when the highest court in the land has already established a broader official one. This case sets a powerful precedent. Heavy rain, in the right circumstances, absolutely can be a flood, legally speaking. And that really brings it all back to you, doesn't it? Your own insurance policies for your car, your home, your business. They're just full of these kinds of words, these named perils and definitions. So, after seeing how one little word sparked a decade-long $1 million legal war, does it make you want to read your own policy a little differently?